Hypocrisy.
Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And with me today is the inimitable, as I stated, Ron Coleman. How's it going, man?
Good evening to you, sir.
How are you doing?
Yeah, pretty good day. Some parts of the day were better than others, frankly, but I think the Supreme Court part of the day was pretty good. Not great, but we had a much bigger stake in the opinion that came out well than we did in the opinion that came out poorly. So
Wait a minute. You're saying we had a bigger stake in the opinion that came out well.
we are firm.
So you guys were in on this. You were in on the grift of the Supreme Court today.
Almost, but not quite. When you get back to Twitter, you will see all the tweets by the management of the Daily Wire taking credit for the outcome today. We, in fact, were not in front of the Supreme Court. We were the lead plaintiffs. We represented the Daily Wire.
Sure.
We were the lead plaintiffs in the Sixth Circuit, and were then jettisoned from that position when, for some reason, the Supreme Court saw fit to hear the virtually identical petition filed by a couple of state attorneys general and some coalition of, statewide businesses instead of Ben Shapiro. Frankly, I don't understand their priorities, but we did. I do think that the client felt very strongly. First of all, I'm positive that I heard stuff that came out of our brief in the opinion and in the oral argument. You'll never be able to convince me otherwise or prove to the contrary.
Right.
But the client, I think, felt, as influencers, as people who are on the internet and helping to shape opinion in a certain segment of the country, they helped. They did two things. Daily Wire. They convinced their employees, that they were committed to protecting them, because the burden on this would have fallen every bit as much on the employees as it would have on the company, or maybe more so. And also that we helped the client demonstrate leadership, by being among the very first to file here and to really lead with an aggressive approach to the 100 employees mandate, which by the way, can I just remind you, I don't know if you heard the oral argument. It wasn't a mandate. I don't know if you heard Justice Sotomayor. It's not a mandate. It wasn't a mandate.
Right. Well, what was it? Because it wasn't a mandate. I also heard I also heard this idea that it wasn't a vaccine mandate, because it was actually just a masking and testing mandate, which was similarly untrue.
It is, one of the first things that God told Adam to do after his creation was to name all the creatures in the Garden of Eden.
Right.
The power of speech brings with it the power to name, and the power to name brings with it the power to frame.
Yeah, that's correct. That's
correct.
I mean,
you ever seriously have you ever made the mistake of saying it, like, during an oral argument? You're right, Judge. They don't like that.
No, but the power to name is the power to frame. If you get to control what a thing is called, then you get to frame how the argument goes. I mean, that's the entire purpose behind Congress's idiotic bill naming structure, right? It's like, oh, it's the Mercy Act or whatever. It's the mothers engaged in rapacious control of mercy there.
or where they name something after some God, God love them, some terrible victim of some terrible crime that inherently makes the bill meritorious because that was how little Johnny died. The Little Johnny Act. The Little
Right.
Johnny.
Yes.
Anyway, yes, it was so that was exciting for us, although not elating. We weren't elated over it because we really did expect it. I mean, you know how it is when you're a litigator. You're hardly ever overjoyed. You're mostly relieved over any result.
Right.
I'd say that
Right.
as someone who's never won a big jury verdict. Money, as a plaintiff's account. I suppose if you won like $100 million jury verdict, perhaps you.
Joe Jamel was probably elated.
I don't know. That only video I ever saw of him, he didn't look like a very happy person at all.
Wait, is that the deposition?
The deposition, man. I mean,
yeah, but he would go on to win the largest. That was the largest award ever. Still undefeated.
That's something.
But okay, so let's kind of break down what actually happened, because we had two rulings today. The second one was, in my opinion, it was the expected result. I don't think it's correct, because I just think the idea that we're mandating any of this stuff is and through these administrative agencies,
right. So let's wait. So I actually did. I wasn't going to give you $1 for a super chat. I wasn't going to give you 10 cents, but I did try to get your attention once, which is foolish, of course. You have all these people throwing money at you and room keys and stuff like that. But I did tune in for a while before I decided to do my own. I decided to do my own spite stream, and you were making these very libertarianish and very valid points about human dignity and liberty and all the things. You were quoting Ayn Rand.
I was in it. I was in the groove, man.
You were in the groove. But we're that stuff is not on the table, okay?
It is on the table. It's always on the table, Ron.
Remotely, you must only by saying that. I now know that you vote libertarian.
Oh God, no.
You're a vote away guy.
I do not vote. The Libertarian Party is terrible.
No, even libertarians acknowledge that.
Yeah, they're not good at being libertarian at all. I would never.
So I agree with you that any forced medical procedure is. I'm not an expert on international law, so I can't really say whether it's a crime against humanity, as many people would have it. But it is really important, since we are explaining the interwebs of law, legal webs of eternity, whatever it is that this show is called, that people understand what was and was not before the court. So that they were nowhere near the moral issue.
No.
They were nowhere near right and wrong. They were not even near, which they could have come near, but they didn't. Whether OSHA had made its case factually, and they were nowhere near a constitutional issue, except in the broadest sense of statutory construction and doctrines that are canons of statutory construction, but don't really refer to any particular. So the reference to the police powers, which is the second case, the first case, not the second case, that's constitutional because of the 10th Amendment. Even then, that's implied. But a lot of people say what you said. People who when you say it, I know that you're saying, hell with all this nonsense. How can we even be contemplating it? And that's correct. That's
you
correct.
might have missed the part of the rant where I did say, now, all of that said, what we're talking about here is because in my opinion, OSHA shouldn't exist, right? Like, as the administrative state shouldn't be a thing that is part of the conversation, just as a matter of course. However, we have this We have the administrative state in the way that we have it. We have OSHA now. Congress
OSHA
has
doesn't apply to Amazon warehouses. I think, it's a good balance.
But we have this system where Congress can delegate to the executive branch this amount of power that they're supposed to hold inherently, because even when this happened, when delegation of authority from Congress to the executive occurred, it was challenged. It was a new idea. The Supreme Court decided, well, no, if they have the authority, they should be able to give it to someone else, I guess, because that's how we do things. And then so once we got there, we're there. And so now we have to analyze things within the realm of where we are. So I have my lofty
by virtue of
ideas.
today's good decision, we might be a little bit less there than we were yesterday.
Right.
Because
Yes.
some little treats hidden in there that are not going to be covered on the evening news, unless Harmeet brings them up on Tucker, because she's quite capable of that, and then some. But these are really important decisions in terms of non-delegation and major questions doctrine. I mean, important stuff. But let's talk about number 2 first, which is what you wanted to do.
Yes. Yeah. Well,
so
yeah.
number 2 is follow the money.
Right.
Follow the money.
Yeah, and that was a key difference in the two cases. OSHA was about the ability for the government to implement this through an administrative agency like OSHA. Frankly, it was a workaround. It's a workaround to the idea that they weren't comfortable just passing a mandate or just decreeing a mandate on the general population. So they thought, we can get a lot of the general population, though, if we hit this worker mandate.
Well, they were comfortable. They just didn't think they could get away with it.
Right. That's what I meant.
No one was losing any sleep.
But the next one was a little bit different, because this is about we pour money as a federal government into these institutions. And so now we're going to buy what we demand. We're going to, and this is the argument of the Solicitor or not the Solicitor General, but her subservient guy, whatever. I can't remember what he's called. Her subordinate, who made the argument. It was basically, yeah, no, we are paying this to these institutions. Therefore, we're going to buy what we want them to do. And what we want them to do is to force vaccinations onto their employees. And I liked how the dissent framed sort of the issues. Because to me, again, for me, both of them are invalid, both 1 and 2. But CMS is more in the ballpark of where we would expect this to end up. And I wasn't surprised by the result, but I was surprised by the dissent and how they framed that the statutory authority referred to by the government there doesn't actually give them the ability to do this, because it focuses on the patients, on the patients and the customers of these institutions, not actually on the employees. And the only time immunization is mentioned in the statutory authority they were taking for the CMS case was in reference to offering vaccines to clients, basically, and offering them the ability to refuse, both of those being in there. And somehow they take, you can offer vaccines for either acceptance or refusal, to you now must mandate it for your employees, which doesn't make sense. And I really like how the dissent brought that out of, yeah, they're citing all these statutes, but none of them say anything, or all these regulations, none of them actually say what they're after.
That's right. And that is true. But the fact is, this has been a common way of hanging things on statutes, finding pegs to get where policymakers want.
Oh, yeah.
Since well before you and I were born. And it would be a certainly strict, it would be a major news if they had found that Congress has to actually say things in order for them to happen.
Right.
I mean, and there's a gazillion. I mean, there's so many objections to it on so many levels. And yes, it it is different. The heights of beds is an immensely different thing from putting your healthcare employees at risk of complications or anything. Let's just put that in the black box called a coerced medical procedure.
Right.
Not the same thing. Not the same thing. But you do have this idea that when Congress says you can have money with strings attached, they're going to attach strings. And I think you're right. It was inevitable that it was going to go this way. In fact, Roberts probably had to, donate a kidney just to be allowed to control, the 5-4, decision.
What do you think about Kavanaugh on that 5-4 decision? Because I saw an interesting opinion that basically I'm trying to figure out how exactly to word it in the way they worded it. But the tweet was accusing Kavanaugh of agreeing with the outcome, but disagreeing with the law behind it, so to speak, if that makes sense.
Well,
Or maybe that was
that's an odd thing. That's the kind of thing that you concur.
Right.
That you concur with. I would say this, that you and I are in part guilty of encouraging this by allowing amateurs to opine on such matters.
How dare we? How dare we let these rank amateurs speak about the
When
law?
really, well, because the people of law Twitter, I think, should be managing that process entirely. And I think, like Pete Barara in particular, there should be just certain captains. All right. Anyway, it's a big mistake to look at a judge or a justice's opinion in one case, or even in a year of cases, and decide he's not on our side. It was a bait and switch. He's going to turn out to be pretty much what was expected. On party line, this really was a harder case. Let's now, the thing that's really important for people to understand is that although the dissent did a very good job of framing it in a way that made the problems with the majority opinion obvious,
Right.
it's an entirely appropriate and common approach to deciding a case to frame it in an entirely different way. That is also appropriate. And I'm not defending the outcome of the decision, but again, there is a concept of, look, when the states decided to allow themselves to be hoarded out to the federal government, to be the federal government's nursing home bitches. Okay, any classical economist or political scientist could have told you that sooner or later, some act of tyranny, but it's just medical care. It's never just medical care. It's never just
right.
Once, there are states that 10% of their entire state budget was Louisiana.
Yeah,
was
it was even bigger than 10%. It was a comical amount.
Well, what does Louisiana do? They probably don't have hardly nothing else, right? They have prisoners building roads, right? And there's $14 for flood management, and
and then the rest is Medicare.
Medicare for alcoholics. So we don't have. No one watches this in Louisiana, do they? So
only the good ones.
So it's not surprising that it'll come out this way. And again, you do have this idea that the money comes with strings attached. It's not really an argument in and of itself to say, but there were never strings like this before. there are always, and I'm going to use this again when we talk about the next case, there are always new cases, there are always new applications to general principles. And when we argued the Slants case, I learned about something that and briefed the Slants case that I had not really known before, which was that Congress, I mean, I must have read it, but I didn't really have to master it. Congress can make conditions on how money is spent, but those conditions have to follow the overall policy goal of the statute. So if you,
and they can't be coercive, right? Like they can't, and this is where I felt during oral arguments, once they got to this nature of basically both sides accepting that, yeah, they can probably request this, but the question is the request coercive? Is the amount of money involved rising to the level of coercion? And it basically seems like the Supreme Court standard on coercion amounts to, is it all of the state's budget? Because if it's anything less than all, it's apparently not coercive. And that's a long-standing idea. I mean, that goes all the way back to changing the drinking age. When South Dakota was the state to fight it. And I think something like their Department of Transportation, or the dollars from the federal government, amounted to something like 20% of their entire state's budget. And they're like, nah, it's not coercive though. And it's like, well, I mean, that's a lot. Like, that's a lot of money coming in.
It's a tremendous amount. Yeah. I mean, that is one of those plastic, like very reasonable sounding criteria that when you drill down, you realize it's nothing but mush underneath. It's not, you're not drilling, you're hitting marshmallow. You know?
Yeah.
So, you know, it's not a crazy outcome, and I really can't say. You know, there was a tack that was taken, and again, this is much more. It's relevant here actually for both cases. During the oral argument, it was remarkable how much restraint the challengers, the petitioners, maintained while being asked questions that were premised on preposterous misinformation, fake news, all the stuff that everyone talked about all in the previous week, all the wrong, and it wasn't only from the liberal justices. Roberts said stuff that was wrong.
Yeah, I thought you said it wasn't only from the liberal justices.
No. Alito said stuff that was wrong. Sam Alito, man, come on. Jersey Sam. So the reason for that, of course, is that there are a couple of reasons. One is that it's not a good idea to have a fight with a Supreme Court justice. There are times in oral argument where it's appropriate to say, well, that's not this case, Your Honor. But given the publicity bubble here, I think a smart policy, they didn't want to allow themselves, either in the court or outside of the court, to be put in the box of being against vaccination. The official elite opinion in the world is that vaccination is an unalloyed benefit to humanity.
Right.
And there's no sense in dying on that hill in the Supreme Court. It's not going to get you anything.
Yeah. Well, all of them are vaccinated, and boosted and triple boosted and whatever. The funny thing is the level that we're at the Supreme Court, like when we're getting to issues like vaccination on a personal level, the big drama I kept seeing throughout the week is that Gorsuch kept showing up without a mask.
Yeah.
And we got the liberal justices like slowly dropping out of in-person appearances, like terrified of this idea that someone with 85 vaccines pumping into their body is going to transmit and all I'm thinking is, you're making a ruling on the fact that workers are going to go into the workplace and put unvaccinated people at risk, and that the vaccine is going to prevent it. Yet here you are with a guy who's got all of the vaccines in the body that you can have, plus then some. He's got some of the cult ritual stuff too. That's a joke. But he's got some of that coursing through his veins, and you're scared that he's not also wearing a mask, as if your ultra vaccinated self is somehow vulnerable, and you're not realizing that that's part of the argument, is that you're not, you're either not in danger or you're not alleviating the danger that you're in. And so therefore, if you're not in danger or not alleviating it, all of this is arbitrary and capricious at that point. It no longer matters.
So this, you're 100% right. And this bending like a reed, but not breaking, went so far that even every time Kagan or Sotomayor screeched something about unprecedented, which is garbage reasoning, they didn't come back with what I thought would have been an eminently reasonable response, which is everything's unprecedented. Nothing is really ever the common law is meant to deal with unprecedented.
Right.
And the interesting thing here is that in the Slants case, the question was, I'm not one of those, if you're a hammer, everything looks like a nail, but this happens to be like one of the things I learned in the Slants case. The question was, does the trademark statute, the Lanham Act itself, impermissibly burden free speech by singling out disparaging trademarks and saying that they can't be registered?
Right. And here, to the audience who may not be familiar with the Slants case is about a band, an Asian ethnic band called the Slants, and the joke is about slanty eyes, for example, and they tried to trademark their band name. And when they went to trademark it, the U.S. Patent and Trademark Office said, no, we won't trademark something because it's offensive speech. It's a racial slur, so it won't be trademarked. So this is a content-based restriction on speech.
It's actually, it was a viewpoint. You're right. It was not viewpoint neutral, and the Supreme Court said that even though, so one of the government's arguments was, listen, it's a privilege, it's not a right to have your trademark registered.
Right.
You still have common law trademarks. You can enforce them in many respects, and it's a privilege, not a right. So the response to that is, Congress cannot give out privileges on and withhold on an unconstitutional condition. On the other hand, if Congress were to allot money for building an art museum and said that there will no piss Christs, it could do that, because the purpose of that statute was to fund a certain kind of art museum. That would be reasonable. Okay, I don't want to go down the alley here. What I mean, the only reason I'm bringing this up is that's where Congress actually passed a statute, even though the Congress that passed that statute, their grandchildren have already passed away. Okay, but
right
here you don't even have Congress speaking. You have agencies speaking, and and during the oral argument, it was actually very compelling theater when I think was it Roberts or was it Alito who said, did you just go through every federal agency and say, how can we do it in this agency and how can we do it in this agency? And then he said, well, not really, not exactly. But here's a quote. Here's a quote
where you said you're doing literally exactly that. Yeah, I don't remember which one it was, but it was, and this all came about, and I thought this was interesting right at the beginning of the OSHA decision, that they highlighted very specifically Joe Biden's words. And there were a couple times that they tried to do this to Trump, sometimes successfully, sometimes unsuccessfully. But they said with the immigration bans at the appellate court levels, they were doing, or not the immigration bans, but the Muslim country bans at the appellate court level. They didn't. Oh,
he wasn't even president,
right?
And the court explicitly held that's cool. No, you could. That's information, and I think that's outrageous. But
I do too.
Information the court may consider when determining whether a pretext is being offered for a putative, reason for passing a statute.
Right. And in this case, Joe Biden had said, we want to increase the number of vaccinated people. He didn't say anything before the OSHA mandate in his September announcement about increasing or protecting workers or increasing workplace safety.
And it's
None of it.
incredibly ironic for a guy like him who grew up in the coal fields, and then, all the time he spent smelting steel, as a young boy instead of going to school, which explains much. That workplace safety wasn't foremost on his mind, given his hard scrabble background.
Right. Well,
That was a laugh line, Rick. Rick
that's
Nieta.
that's what he runs with. He runs when I was in Scranton all the time. It's like, Joe, you haven't been a hardworking man in ever. You've been in Congress for 453 years. But no, it's crazy that wasn't his focus. Because that has been a thing. It's very socialist adjacent as well to be pro worker and I wouldn't call Biden an overt socialist, but he likes to ride that socialist adjacent area. This idea that the middle class, is the premier class that government needs to focus its attention on and funnel
Well,
people
remember
into.
when he decided to lift wholesale someone else's speech, he went right to Neil Kinnock, which might have been before your time, but I remember what a commie that bastard was.
So I have a question for you, because there's been an ongoing debate, there's been some discussions in various areas of the YouTube side of lawyering, I guess.
Is that what it is?
I don't like calling it. I don't like calling it LawTube. I hate the name LawTube, right? And because I hate law Twitter with a passion, with a fiery passion.
Somehow that sounds familiar to me.
Yeah, right. And so like LawTube is equally offensive to me.
So I think this is the YouTube section of the American Bar Association. Oh no, we hate the ABA also.
Yes. with even fiery passions. So but anyway, like Nate the lawyer has been taking a lot of heat because of his statements about mandates and the legality of them. And he referenced Jacobson. And I wanted to ask you, are you familiar with Jacobson?
Are you kidding? Listen, my family has multiple generations of imbeciles, so we've always taken it very seriously.
So for the chat, Jacobson is the leading case from the Supreme Court on vaccine mandates. It was the state of Massachusetts implemented a vaccine mandate, and the way that they did it was you either got the vaccine or you paid a criminal fine, and the criminal fine was $5 in 1903, which is about $150 today. And it was not argued on these grounds, but I was reviewing Jacobson in kind of to get my mind in the right space for the discussion of the SCOTUS stuff. And I'm reviewing it and I'm thinking, okay, so the mandate is either do this or get this vaccine. And that was it. It's nothing like today where you have the mandate then involves your ability to have employment, to go to, restaurants or amusement parks or anything like that with some sort of vaccine passport that we see in a couple different states and cities. It wasn't anything like that. It was literally just vaccine or pay. And that's been held up. And I feel like that would have been more vulnerable to an arbitrary and capriciousness argument, but I don't know. My Supreme Court jurisprudence timetable isn't up to date, but had we even developed like the arbitrary and capricious approach to these sort of things? Because to me, if a regulation can be defeated by a rather trivial fine entirely, if it's obviated by $150 payment, we'll adjust it for inflation to the government, then that seems the very nature of arbitrary and capricious. Because if the goal is to have people vaccinated, then, for safety.
Your argument proves too much, because then every penalty has that quality. And it's a given that monetary penalties are meant to provide a punitive / incentive, a punishment and an incentive for noncompliance.
Right.
And let's analogize to the law of contempt of court. A court will not keep someone in prison forever for refusing to answer an interrogatory question or to testify under subpoena, to identify the source of information. If the court determines that you're not going to this isn't going to do any good, this person will stay in jail. They've been in jail for a year. They're not going to tell it. Let them out. We're not here to, we're not going to, this is not like a whole punishment thing. So,
Sure.
So in the case of that's like saying, listen, making somebody pay $300 for a speeding ticket isn't going to make it. I'll pay the $300, but I still sped. No,
Well,
you're
but
not going to speed tomorrow because I'm going to catch you again. So next time, if we have a policy that,
but in Jacobson, it was once you, I mean,
once you did it, you were done for life.
Right, that's the thing. And so and there's a conflicting issue here because well, speeding's one issue because the danger is ongoing. In Jacobson, not getting vaccinated, presumably the danger would be ongoing forever, right? But it and so it's weird to me that was allowed because that was allowed to go on. There was no mechanism to actually force the vaccine onto someone or to prevent them from integrating into the public. So it, in
also,
theory,
we have to keep in mind that the entire jurisprudence of individual rights was so immature historically, and that's what you're getting at.
Yeah,
we didn't have the narrowly tailored criteria, and all the stuff, all these different. It was such a much more basic and down to earth situation then, and in a way, that law, on the one hand, that law was more, it was like you said, it wasn't as all encompassing. On the other hand, it was much more of a radical departure in American life. Although there were, having litigated many of these of the lockdown cases in 2020, there's a standard couple of paragraphs that all the governments put into these briefs, which tell you just how common it was beginning in the late 19th century through the early 20th century when before infectious disease treatment had really reached the incredible zenith that it has now, where they know exactly what they're doing. You didn't have there was still this kind of antique concept of using quarantines and using those kind of medieval ways of dealing with plague in a country that was moving from rural to urban. So your point is well taken, but I think we are really comparing apples and oranges. But what I think is fascinating is if there had been some discussion of do we have to rely on Jacobson, and I think ultimately that Jacobson was not at issue here, because in both cases it was about as Gorsuch put it in the first sentence of his concurrence in the OSHA case, this is about who gets to decide.
Yeah, and Jacobson, well, one of the main reasons Jacobson wasn't at issue was because it was quintessentially dealing with the state's authority to implement a mandate, and Jacobson is silent on the federal government's authority on the validity of it, and muses that the federal government may, through Congress, have the power to do this, but also may not. It's a very different question. But of course, in the case that we have, Congress did not act, right? Like there's nothing. OSHA's passed decades ago, and is ultimately
that seemed to really grab Roberts by the throat. The idea that this law has been on the books for 75 years or something, 80 years, and no one ever dreamt, no one ever tried to do anything like this before. And I actually don't think that's a particularly strong argument, because if you accept the premise of the screeching 3 votes to the contrary on this case, unprecedented, people are dying every second.
That's Breyer right there.
Right. That's an answer. That's a response to that. No, whatever. But I do think it's I do think it's very relevant to say that the what were we just talking about? Not Jacobson, but
Well, we were talking
yeah,
oh gosh, I'm trying to remember exactly how to word it. Well, we talked about whether or not Congress had acted or the
right.
this case it was the
Congress had not acted, but so in the concurrence, Gorsuch's concurrence says if we had, it wasn't necessary for us to reach the issue of whether Congress had acted. But let's be clear on this: Congress has no such authority. I mean, that's from a concurrence, but that's a little gem that's going to come up. That's going to be useful in the future.
Right.
Well,
I think Congress is terrified to pass this. This is why it went administratively, even though the Democrats theoretically control the House and the Senate. They would have problems getting this through the Senate. But let's say by some miracle they could, right? They could convince 10 Republicans and all of the Democrats to vote one particular way on this and actually pass a mandate. And there's some thought that they could. There's no way they're going to do that before midterms. There's no way that the Democrats are going to pass a vaccine mandate going into midterms, already very concerned that they're going to lose the midterms and lose control of both houses. That would put the nail in the coffin. That would so energize the Republican voting base. I think that's the issue.
Not only Republicans. That's the point. It's not only Republicans.
Right. Yeah. But it would bring out so much that would seal the deal. So they were never going to do this through Congress. However, after the midterms, there's a possibility, depending on how that plays out, that they could try and ram through some legislation to get this up there.
If they maintain control, the Democrats maintain control, which they're doing everything humanly possible to make sure that they do by regularly trotting out, the Horst Wessel song. The Reichstag fire of January 6th,
yes,
our national day of mourning.
If they can just keep those guys in prison through the midterms without trial, that'd be so beneficial for them. They get a bunch of guilty verdicts going through October. Just have publicly televised federal charges for the first time running through October.
All of a sudden they'll decide this, the time has really come. Actually, I believe that would blow up in their faces because
I think so too.
Yeah. And I think they know it.
I just want to see him try. I think that'd be funny. I'm all for the comedy of it all. But the thing I wanted to bring out with Jacobson is I think we have this interesting. This is my problem with how precedent and stare decisis plays out, is because I think if Jacobson were argued today without Jacobson existing, we would have very, very different arguments about the case. And I think, might even get to the opposite outcome. I think they might say that, no, this is an infringement on individual liberty. This is, and again, with the nature of a vaccine being intended to, with the arguments that we had,
at least today, you mean with this court, right?
Yeah.
So John Roberts,
well,
he loves him some state police power.
He does. That's true.
It's true that this was a lost opportunity for the court to enact the federal police power over workplace safety, mooted during oral argument by the former dean of Harvard Law School herself. But notwithstanding that flash of intellectual inspiration, it is the case that no non-intoxicated person disagrees, but that there is no federal police power. And to a large extent, the horrors that the Roberts Court inflicted on us before the passing of Justice Ginsburg was a result of this misplaced, but nonetheless not completely illegitimate respect for the state to decide the scope of its police power. Now, I think there are two things going on here. One is that it's entirely appropriate to consider it, and especially like you say, look at Jacobson is one thing, but look at the all-encompassing nature. And on another axis, at what point, and this was asked during oral argument, when did these emergencies end?
Right. That was the whole, even the idea in the context of how this came about. Joe Biden is talking about this in September. So it's emergent in September. Then we have it not being actually codified until November. Is it emergent in November? Now we're into January arguing whether this can go into effect. So in November, they put a deadline that starts in January, ends in February. It's like, oh, how emergent is it if we're already at a 6-month window? Right. And then how far into the future does this emergency power extend? And one of the justices even said, well, it's whatever the secretary determines to be the emergency, right? Like the secretary can just determine it's an emergency ongoing forever.
I'm almost, that was either, there was the two contestants for that slot on The View. That was either Justice Kagan or Justice Sotomayor. I couldn't believe that when I heard that. I couldn't, I mean, and that was actually, that was what I think made me tweet something that I think got 12,000 likes, which was, we have some serious coercive statists on the Supreme Court. I mean, look, you notice no one's really interested in talking about Breyer. He's just off his rocker.
I've
off his rocker. He wants to decide everything based on equitable considerations. Maybe it's me. It might be me, but you tell me. You tell me. Is it good or is it bad if people are dying every second?
I said this, Breyer, I disagree with Breyer's opinions. Just fundamental differences in perspective on what the Constitution is between me and Breyer, and that's never going to change. But I don't mind
a document that is American, for example, because he seems to think that all the nations of the world have something to say about how we
right. Yeah, I think it's an American document that has the portions of it written in the time and place in which they're written. You could call me an originalist, I suppose. I don't like labels, but that's my general framing of the Constitution is, well, what did they mean when they wrote it? I mean, that to me, that makes sense. Not what do I mean about what they wrote, but what did they mean when they wrote it? And if I think it needs to mean something other than it means, well, we have this cool little amendment process and we can just go ahead and do that if we think, if society agrees. And that was the idea behind the whole thing. So, I mean, I'm going to disagree with Breyer because I don't think the court should be involved in this. I take more of the Scalia tactic of, we remove these things from democracy in the amendment, in the constitutional amendments. But
the Obergefell, what he mentioned Obergefell, I mean, I think he really nailed it there. He said, it was going state by state. It just wasn't going your way.
Right. Just pass a law. And one of my favorite discussions about this, Scalia is talking to some interview he did, I was listening to on YouTube, about the Eighth Amendment specifically. And he's like, the Eighth Amendment gets rid of cruel and unusual punishment as it's understood in 1790. But other than that, like we through the court have rolled back and we said, well, we don't want the death penalty to apply to minors. It's like, well, why? Why does the court have any say in that? Because the Congress can just pass a law that says no death penalty for minors. The court doesn't have to make this a constitutional provision. It wouldn't have been at the time that they wrote this. The death penalty applied all the way down to, at best we can figure, the age of 12 seemed to be the cutoff. So younger than 12, maybe not okay, but 12 and up, sure. But if you don't like executing 12-year-olds, just make a law that says you can't execute 12-year-olds. The court shouldn't be involved in that. And so that's my approach. But understanding where Breyer comes from makes me, I disagree with his opinions, but I don't really have a big problem with them. They make sense from his perspective. I just hate the way he talks about law. I hate the way he asks questions in the Supreme Court. Every time he talks, I want to ram my head through a glass window and then rub back and forth and hope I end up dying from it.
And it seems to be the real him. Like, I mean, it's funny that you say that, because you just saw me go out of my way to kind of mimic him. As far up the curve to mimicking a Supreme Court justice. Well, I'm not getting his vote in any case that I might have. Who are we kidding here?
You're not arguing on a side that Breyer's going to agree with.
Well, no, I didn't. Come on. I got his vote in the slants. Come on.
You have a new goal in life for me. This may not be your goal, but it's my goal, is that you will be in front of Breyer and he will directly cite an interview you were on with me where he's like, I don't like that guy that he's on the internet with.
I would be so happy for both of us. If it were
Making Breyer watch one of my videos would make me happy. If he's ever charged with a crime, I'm going to Amici in and demand that the punishment for his crime just be like the hour of community service of having to watch one of my videos. That'll be like, trust me, this will hurt him more than anything you could do.
Everyone's writing at the same time. I don't understand. Who's the rabbi in the other window? What is it going on?
What are we learning about Torah here? I don't understand. But
you know what you've done between me and Joe Neerman to raise Americans' awareness of how many Orthodox Jews practice law?
Disproportionately represented on the panel, I think.
Yeah, as if the whole country didn't already think that New York was just full of bearded, skull-capped wearing lawyers who talk with their hands. Right. Anyway.
Well, come on. I have Nate too, the other New York attorney.
You think that balances us out?
Yeah.
Equity, right? Equity.
Yes, equity. Oh my gosh. There was something I wanted to ask you about. Oh, now my brain is losing it.
Man, you're on Central Time. Come on.
Yeah, I know. Look, it goes in waves, right? And so now I'm going to circle back to a different thing, like Jen Psaki. I'm going to circle back to something we were talking about with Roberts and the state police power. This is one of the key differences in the two cases that I think this is where I thought Roberts was going to side with the liberal justices in the second case, was because it was about the spending power, right? Like, and we know from Roberts penning the Obamacare decision that he loves the spending power. Like that's his favorite thing on the planet, is the idea that the government can buy what it wants.
So one of the important things that came out of the OSHA case was implicitly a little bit of trimming back of this expansive tumor of the Commerce Clause, rationalizing every conceivable congressional interference in American life.
Right.
And this is one of the most difficult topics because, there was a lot to be said in an abstract sense for using the Commerce Clause to say, we're going to use it to attack Jim Crow, because Jim Crow was such a nasty, such a, to come back to the cancer metaphor, such a cancer on the body of American culture and politics that, it does seem as if almost anything would have been justified. But it was a distortion of the Commerce Clause. And we end up now in a world where, in the area of law that I used to practice much more than I do now, but for the previous 20 years, one of the issues in trademark law about whether or not a trademark is used in commerce, which is when it's necessary to be done, for it to be entitled to federal registration, is what constitutes use in commerce. And it used to be that there was a general sense that use in commerce meant at least some sales across state lines, because otherwise, how does it become a federal issue?
Right.
Well, since the Commerce Clause goes everywhere, you can use your trademark entirely locally, and that if that use is sufficiently oh dear, I should never have brought up trademark law. I'm sorry.
It's your fault.
If that use is, while he's coughing, I'll explain if that use is sufficiently pervasive that Congress could regulate it, which means basically anything.
Right.
So it's become, it has use in commerce and the Commerce Clause in general are tricky. So one of the things that the OSHA case
They're only tricky because of the worst Supreme Court decision on the books.
Which one is that?
Wickard versus Filburn. The origin of the Commerce Clause expansion, the dormant Commerce Clause, the single most devastating Supreme Court decision. Like you could pick all of the race ones and be like, oh, these are bad. It's like, let me tell you though about a guy who wanted to grow just a little bit of wheat. And it has been the source of all of this nonsense.
Everything.
It all boils back to what, 1929. I think it was. Was it 29? Wickard versus Filburn? Or it's when it happened, I think. And then the case was decided in the 30s.
Yeah, I mean, when FDR succeeded in spooking them on the court packing, and they started finding room for the New Deal legislation that previously they were finding unconstitutional, that was really when we turned the corner. But
I'm off on the date. It's right in the worst part. So it was passed in 38 and the decision is in 42.
Yeah,
so it's right.
I didn't want, not having it in front of me either. 29 did not sound possible to me culturally.
Yeah, no, that seems too early because it was at the time when FDR wants a whole bunch of stuff passed, right, and he wants it now, and the Supreme Court is not going his way on the New Deal, and he comes out and he says, look, start finding the New Deal okay, or I'm going to add enough of you that none of you will matter.
Which basically we're going to start hearing about tomorrow morning, by the way, once again.
Oh yeah. Yeah. The Supreme Court's getting in the way of getting America healthy and safe and all of this nonsense. When we all know that there's no intention or plan to get back to any sort of normalcy. Like this has been the problem. The underlying problem with all of this policy is that there is no path out of mandates, of vaccine passports, of negative test requirements, of masking requirements. Like, because what feasible future do we have where COVID is gone? Because it's basically going to become the common cold, the flu. It's going to be an annual seasonal illness. Oh, that pissed me off, by the way. And they discount comparisons of COVID to the flu by saying, but this is a seasonal illness, so it's different. It's like the flu isn't, I mean, it ramps up at certain seasons, sure, but it's not like it's gone the rest of the year. It's not like it doesn't exist. I mean, the flu happens.
Dishonesty. Oh, gosh.
Yeah.
No, but I mean, I think you understate the matter. To say that there's no plan to end it, the plan, I would have been a little bit more skeptical of this a year and a half ago, but the plan is very much to keep it rolling, at least through the midterms. And that I wrote a little tweet thread on this a couple of weeks ago where I said, all those cases in 2020 that we had to wait until we got Barrett on the court to start turning around on the First Amendment, the lockdown cases, all those cases where the court refused, and also the election cases, it's not merely the fact that the influence of Roberts is to only rule on the narrowest possible grounds and the narrowest possible procedural basis, and to rock the boat as little as possible and to avoid constitutional questions and to avoid reaching genuine ethical problematic aspects of what's going on in and of itself. It's the fact that there's a tremendous ratcheting effect that takes place by allowing bad law to stay where it is for as long as they keep it where it is, to allow so many circuit splits to maintain, to exist, to continue to exist for decades on really comprehensive, pervasive statutes. You reach a point where now municipalities and states are openly passing regulations and rules and laws mandating that certain kinds of benefits and certain kinds of treatments only be available to people of color, which they would never have dreamt of doing until a couple of years ago. But why? We see the Supreme Court doesn't take cases. They're waiting for just the right case. They're waiting for just the right moment. They're waiting for just the right number of votes. And so there's no review of the circuits. The circuit courts are the highest court in virtually every case. And I mean, think of the crappy opinion that was ultimately reversed in the OSHA case here. The crappy opinion of the Sixth Circuit. They took a stay from the Fifth Circuit. They took a stay that had been entered by the Fifth Circuit before we got involved. We filed in the Sixth Circuit thinking we were the first in the country because we had prepared for this. As soon as the regs came out, we were going to file.
Right.
We woke up the next morning, there had already been a stay entered in the Fifth Circuit.
Like, good God. Like, did the judge sua sponte stay this thing?
I'm sure the Fifth Circuit, that would be about, So they get to the Sixth, and then it's all consolidated into the Sixth Circuit. And what's the next thing that happens? They draw a good liberal panel of the Sixth Circuit, which was much less likely in the Fifth Circuit. And essentially, the Sixth Circuit reverses. They make a motion to lift the stay, saying, "Oh, something's different now. Yesterday was the 21st, and today's the 24th." I mean, that's the kind of differences we're talking about.
Right.
And essentially, the Sixth Circuit acted as a reviewing court on the reasoning and legal conclusions of the Fifth Circuit, completely jettisoning the law of the case and second guessing a sister circuit, which is entirely inappropriate. But the Supreme Court doesn't do anything about that. And they didn't say anything about that in the opinion. And that's really a problem. It's really a problem. It's out of control. And for Roberts, for all his, somebody made a great point earlier, about 6 months ago, saying Roberts thought that he was going to depoliticize the court by being so, removed and trying so hard to avoid the court being perceived as political, but his actions have resulted in the completely contrary outcome. And this is another aspect of that. It's a disaster. No matter what decisions end up coming out through the pipeline during the rest of his term, and he's going to be around for a while. It's not that old of a man.
No. Unless COVID gets him.
I'm laughing. I mean, COVID does get people. I don't need to laugh at that. Listen. A lot of our conservative friends, I have seen people tweet, I never heard of any. No one I know ever got COVID. I don't know. I know a lot of people who are dead from COVID. I know a lot of people who are not around anymore in my neighborhood, and whose parents are not around anymore because of COVID. It's real. It's very real, and it's not a joke. My friend Dave Reboy got very sick in Miami. This guy, he's a bodybuilder. He's in incredible shape. The only comorbidity might be that he's bald. I understand that's a very serious matter.
Very dangerous. Very dangerous.
Yeah, so it's a real thing. But everything else, for most people, it's right now, it's a prison. And most people who are young, most people who are blah, blah, blah. Oh, I'm running out of words.
No, it's that's the thing. But Roberts is going to be around forever. And when we have the court acting in the way that you're talking about, and the people who know this most intimately and acutely are Second Amendment supporters, right? Because you cannot get the court to take a damn case on the Second Amendment, and they're allowing states that are running directly contrary to their most recent decisions in Heller and the Mick whatever it is, the Chicago one. You have states like Hawaii and California, New York, even just making things so obscenely difficult that they make it's like this should be overturned in a moment. I mean, the law that they passed in New York City about the transportation of a firearm to and from a firing range, one of the 5 approved in the city firing ranges and nowhere else. And gun owners going, but I have a house in New Jersey, a second house outside of New York in New Jersey or in upstate New York or whatever. And I can't bring my gun to my own property without violating the law. This is a clear violation of keeping and bearing arms. And they're like, no, I mean, you can keep it and bear it in your own house. And then in your trunk, locked up and disassembled with a biometric scanner and a little elf that you have to ask permission. And then when you get to the range, you can keep it and possess it while you're on the range, and then you can put it away. And the genuine question was, what if I have to stop at the grocery store? And the fact that the city said, we don't think we'd enforce that. We're not sure, though. It's like this is an affront to the very core constitutional issue, and we cannot pay, beg, threaten. There's nothing you can do to the Supreme Court to get them to take a case. Yet they'll take 10 First Amendment cases a year without any issue. And these are not like, these First Amendment cases aren't really forging new ground or asking groundbreaking questions. And we're trying to get the very fundamentals of the Second Amendment on the books, because there's 3 cases total, and 2 of them are just mirrors of the same one. Heller and the Chicago one are basically saying the exact same thing. And the other one you have is Miller. And when you think that the foundational law around the Second Amendment goes to Miller, which was argued only by the government because the other guy's attorney didn't show up and he was dead. And that was, and the court's like, fine with this idea that the only argument's going to come from the state, and it's incomplete, and it's, the National Firearms Act is facially unconstitutional, but we've had it now since 1939, I think it was. And it's stuck forever, but we can't get a court to clarify this. We can't get a court to actually review Miller issues. The closest we get is this damn concealed carry issue in New York. And it's like, this is not broad enough for what we need. You're talking about, I can analogize this in a way that's probably relatable to any other like feeble white children like I was. My dad we would go to the gym or whatever, the health club, and I would go to the basketball court, and I get bored really quickly because I never really liked playing basketball that much, but I would try doing trick shots, right? Because I had nothing else to do, and I wasn't like practicing the fundamentals of basketball. I was way too small as a kid, for sure. And so I would do trick shots, and my dad's like, you're never going to be any good at those trick shots if you don't do the fundamentals, right? And every Supreme Court case now on the Second Amendment issue is a trick shot. It's this New York transportation thing, or now it's the New York. We're refusing to issue permits to people. It's too hard to get a permit, and I'm like, bitch, permits. Where is the permit in the Second Amendment? Where do I have to get a permit to exercise my First Amendment rights? Where do I have to get a permit to have a right to an attorney? You're way down the line here. We're conceding so much ground, and the Supreme Court hasn't even gotten to the core issue of, is a concealed carry permit even permissible under the Second Amendment? And that's just pissing me off.
It's terrible. It's terrible. There's really no serious review. And also, there are really so few serious judicial officers now. I mean, to think that 3 members of the United States Supreme Court, including a former dean of the Harvard Law School, signed on to that minority screed today.
Is that Kagan? Who's the former dean?
Kagan,
yeah. But no, see, but I knew Kagan. aside from the liberalness, I knew Kagan would be on this
No, but
because
liberalness. Okay, so Brennan was a liberal,
right.
and Brennan was not a rocket scientist, but he was a judge, for God's sake. These people aren't even judging; they're emoting.
Right.
They're emoting.
But Kagan was brought on for health issues in a particular perspective, right? Like she was appointed for the Obamacare decision. That was a point of putting Kagan on the court. And that's why I think
that's exactly why she should have been recused.
Yes. Well, she argued it before the Ninth Circuit, right? Like that was, she's arguing it, and then she's ruling on the appeal of her argument, which was ludicrous.
Unbelievable.
But so I think Kagan's interesting in that way because I do think we get some unexpected takes from her on other issues.
Yes.
Because of that.
She has the firepower. She has it when she wants to engage it, but in a way that makes it more frustrating because she obviously knows how corrupt the enterprise is that she's engaged in.
Well, yeah, she was at Harvard. She knows all about corrupt enterprise. How's that gradeflation going, Harvard? It's amazing how many of your students have 4.0s. They're all just really hard worker. None of them are drinking and having sex like the rest of college students in the country.
Well, on that note, speaking of corruption, my consciousness is starting to get a little corrupted. If you want, though, I'll take a couple. If you want to do a couple of super chats or something, that I can participate in before I conk out here.
Yeah, let me scan them real quick. So Stupid Monkey says, I think the best part is the rest of the world must hate us right now. All information comes from U.S. media. Then a lot of other countries implement mandates. Now U.S. Supreme Court says unconstitutional, so we can't. Lol. There's a
lot of incorrect things to unpack there. Believe it or not, I don't think as much of the world is as interested in what the Washington Post has to say as we might think. Secondly, they were before us on everything because it swept through Europe before it came here. They invented the lockdowns. They were the first ones to gobble up that Chinese propaganda about lockdowns. I don't think, and I think, they tend to be, I think, actually, I don't think they think, almost anyone thinks too highly of the United States anymore. So, I mean, they've been laughing at us for a while.
Yeah. And well, when with men like Joe at the helm, how can you not laugh at us? Frankly, Ham and Beans says the government working with private companies to coerce citizens into compliance. Last I checked, that was fascism. And he also says any man like Kavanaugh who cries before Congress is going to cry before the law. He has no hot dog. Let's see.
But he likes beer. He likes beer. You got to get manliness points for liking beer.
He likes beer and fart jokes. That was the when they're like talking about someone wrote something about breaking wind in a yearbook. And they're like, what did you mean by that? He's like, I mean, I'm 18. It's a fart joke. That was amazing.
But I don't think Thomas appreciated you much when he first came on the bench and asked him to pull his finger in their first, By the way, how about that just that Clarence Thomas?
He's amazing. I love him.
He keeps his mouth shut for 25 years. Not a word.
Yeah.
And all of a sudden, he blooms like a flower.
Well, Scalia was saying everything he wanted to say. He didn't need to talk. Nah, Scalia. Nah, Nino, you can take it. You can take this one, Nino. I'll sit over here and just listen. I love, I started listening to interviews of him on YouTube. It was either last year or early this year. And I ran through a whole bunch of them, and the guy's just fascinating. And it's funny because if you listen to the media talk about Thomas prior to Scalia's passing, And they just constantly like, oh, you shouldn't even be on the bench. You never asked any questions or whatever. He doesn't even know what's going on. And then once he started talking, they're like, oh, Christ, I wish you would stop talking. Just please.
Well, I'll tell you something fascinating. So I've been catching up a little bit on my CLEs.
Oh, God, haven't we all?
And
I had to get an extension on my turn-in dates.
so I was doing this course in communications law. And one of the topics was, the topic was, the panel, it's PLI out of New York, and they tend to put all these liberals. The media law bar tends to be overwhelmingly people who work for major media companies. They almost never have, like, the premise is, of course, defamation laws are bad, and et cetera, et cetera. It was nonetheless a pretty balanced presentation. But one of the presenters said, how many times have we joked about things that Thomas has written in dissents or concurrences, which 5 or 10 years later turn out to be the root of an entirely new jurisprudence on a topic? Let's stop taking him lightly. Now, he can't live forever either, but he has left taxidermy instructions through the 2024, like Ruth Bader Ginsburg did so unsuccessfully.
No, you're wrong. She was successful. The real trick about Ginsburg is that she had died 15 years prior. Like, that was.
Come on, I've told you my Ginsburg story from the Supreme Court, right? If I did,
I don't remember. Yeah, tell it again.
So people don't appreciate
for the chat
small a courtroom the Supreme Court is. We've all been in federal courtrooms that are 10 times the size of the Supreme Court.
Right, they're huge.
So you're sitting there, and you're not even, I don't think you're even 10 feet away from the justice's bench. And you're looking up at all these movie stars right in front of you. And I'm sitting right opposite Ginsburg. And I'm looking up at her, and she's all bent over. She looks like a street lamp, all crooked.
Yeah. Which doily did she have on that day?
It was Tuesday, right? So it was a Tuesday. And I realized, I kind of see it peripherally. I said, I can't look at her directly because the energy from my gaze could be what puts her over the edge right now.
That's the male gaze they're talking about.
I'm that guy.
Very dangerous. Yeah.
And if I kill Ginsburg today, I need her vote, because all the other liberal justices, and remember, they killed Scalia to get him off the bench for our case. Okay.
No, they definitely didn't kill Scalia. What are you talking about? His death was completely normal. And the fact that his body was cremated and removed before there was an investigation is absolutely common for one of the highest officials in the land.
Okay. I will say this. The man was not the picture of health.
He's Italian. He could be as fat as he wants. It's fine.
It's like James Gandolfini, right? So in Jewish law, there's a concept called a goses. Goses means someone who is on the very edge of death. And if you touch a goses, you're not allowed to touch a goses, because if you touch a goses and that person dies, you're considered to have been the one who pushed them away. So sure. These eyes are like touching.
Actually, Texas agrees, right? We found that out from Kurt Eichenwald, that photons from shiny lights are a battery.
Oh, we shouldn't laugh about the.
We should always laugh at Kurt Eichenwald.
Is he? Wait, he really disappeared after that pretty fast, huh?
Yeah.
Well, all right, let's take another question before I nod off.
Yeah, let me see if I've got.
Someone asked me, by the way, in the comments, how do we keep the little hat on? First of all, as you'll notice, I keep adjusting it because it will fall. Right. But people don't appreciate it. Really, on the other hand, if it's large enough, okay, and this is even without the Velcro effect because the hair is supposed to go, but it wants to stay on. Okay, see, it wants to stay on. You'll notice it never falls off the Pope's hat. Pope's
I
head.
figured there were like little sticky pads, like that grippy
Velcro.
material on the inside,
Velcro.
like a
Velcro.
Velcro.
Or
No,
yeah.
I was talking about like when you have those like those really low profile socks for loafers or whatever, and they've got that sticky rubbery material around the top of them. No, it's not elastic. It's like it's a grippy material on the inside of the. You don't have these socks. Clearly, you only wear very tall socks.
Very tall socks that are, of course, compression socks. And I wear them while playing shuffleboard.
Furby Slayer says Ron, LA Attorney General, made arguments about Medicare being a contract between the Fed and the states and hospitals with the state. Beyond the coercion aspect, is it not states' choice? Ultimately, can the Fed change these contracts at will?
No, they can't. Well, the analogy to a contract is a little bit strange because it's not as if the states can say, we've been shopping around for immensely deep-pocketed central national governments. And once again, we've decided to award the contract to the United States government in Washington, D.C. Okay, there's only one provider. So it's not really a true market choice. But it is very, very common for a funding agency to say that, you will meet our standards for spending the money pursuant to such rules as shall be promulgated from time to time. And if you don't like it, you don't have to take the money.
Yeah, just don't take the money, bigot. Just tell all your.
It was a racist question.
Just tell all of your state Medicare and Medicaid patients that they just can't go to any hospitals in your state. Just tell them that. You just be the politician or the appointed position or whatever who tells them that. You just be the guy whose address is out there that tells all of the boomers in the world who still have their guns from World War II or whatever that you took away their.
Those are the parents of the boomers. You can't have it.
I said or whatever.
Okay,
they still have all their PTSD and violent guns from Vietnam. There you go. They still have all those. Just tell them that you took away their ability to get medical care. You be that guy, because the government gave a very reasonable way for all of them to get free medical care, and you just didn't want to take it. Because that's what I have. I have so many problems with this. It's the insidious nature of it, and it's a system that shouldn't exist in the way it does, but it's built, so we're stuck with it. We're stuck with it in the way it is, and now we're here. We can
This is the whole problem. I mean, talk about the Commerce Clause. I mean, how the hell do we ever get out of that? How can you roll back
Commerce Clause? Ron, I'm the guy who thinks Marbury versus Madison was the exact wrong decision, and that it goes far beyond the Supreme Court's power that's laid out in Article 3, which it does, by the way. They went outside the text of the Constitution to be able to tell the executive and legislative branches that they're going outside the text of the Constitution. And then because of Marbury versus Madison, we don't have frequent amendments to the Constitution. We don't have a quote unquote evolving document because we evolve it through the courts. I hate the decision. I think it's terrible. It's made the Supreme Court into a 9-justice conglomerate that we have today, where all of the cases are funneled and aggregated into here, and they only pick 50 out of the 1,000 that they get every single year. This system exists because of Marbury versus Madison. It wasn't written this way.
It does. We'll have to have a separate session some other time on where you explain to me how unconstitutional statutes would otherwise be challenged, or state action.
Yeah, see,
it's
not that time. But and I'll let you go in just a
second. I wasn't asking it facetiously. Yeah. I'm really curious about how else it would work. I find it's a fascinating topic. But right now, the idea of sleep fascinates me.
Sleep is good. Kurt hates this topic, by the way, uncivil law. He and I disagree on on this one. But that's okay, because I know I'm in the extreme minority, because we have a system, and it's hard to fathom the alternative system, because we would have had to develop it over 200 years, and
Well,
we've gone this way.
it's hard to find, and also the guys who wrote the Constitution were all there watching. Some of them with their mouths agape, but
Right. They
they
watched
didn't.
it happen.
They
Yeah.
didn't go running back to the state legislatures and saying, "Guys, someone, we need to straighten this out. Let's amend the Constitution." So, okay,
Right.
not for
Well,
tonight.
hey, yeah, I will let you go. Thank you so much for joining me and talking about
Oh,
this topic, by the way.
what a pleasure. We were talking about for a long time that we had to do this, but then we get, we ended up getting bogged down in all these trials, and you became a gigantic
Oh,
media star. And
real quick, and yes, we should do another topic sometime, but real quick, just so people know, what cases are, what big issues are you tackling right now? I know you still got Gavin McGinnis versus SPLC. Someone mentioned, when's that happening? It took 2 years for the judge to make a minor issue on the jurisdiction thing that was corrected in 5 seconds. And I don't think it even needed to be corrected. I think that was a ludicrous position by the judge. But so he has another 2 years to go. But what other cases are you? Any big cases you want to talk about that you're working on?
well, yeah, we are, but maybe it's we had a disappointing outcome in the Central District of California on this case where the state of California and various attorneys general were telling Twitter what tweets to take down under the aegis of election security, and they were basically
yes,
outsourcing to Twitter whom to censor. And
a sort of quasi state actor doctrine where it's hard to, because the state actor doctrine is really narrow and might need to be expanded in the scope of how big tech works today, right?
It's a gigantic problem. So the judge, of course, happens to be Justice Breyer's brother, and who, by the way, is much more pleasant to listen to. And it was really, the oral argument was fantastic. But then he basically cut and pasted all the arguments from Twitter's lawyers, which is the custom. That is the practice.
Well, he's trying for that blue check mark. That's why.
So we're filing that. We're filing an appeal to that in the Ninth Circuit. We've got defamation cases going on for Project Veritas. Some stuff that I can't talk about unless I kill everyone listening.
Do you see my book? You see my book I'm pointing at here?
Well, you got
James O'Keefe's American Muckrake. It's blurry. You can't see it, but James O'Keefe's book. I've got it right here. His new one.
I see it.
I started reading it, which is more than I can say about any of the books I bought. I buy books all the time that I don't read, but that one I'm actually working on reading.
Don't I have that one? Oh no,
no.
Oh no, American Pravda is what I have.
Yeah, this one's not out yet.
This one's not out yet.
Oh, didn't you get a copy?
How'd you score that?
Oh, I don't know, Ron. That's weird. Don't worry, it'll come out.
Should I text James and ask him for one? You think?
Well, he signed mine.
You paid for it though.
No.
I'm going to check.
No, you can get yours in 14.
He's on yours at Barnes and Noble.
You can get yours in 14 days. It's fine, Ron. It's fine. It comes out in 14 days. No, he sent me. He graciously sent me a copy, and I've been reading it. The intro. I only have had time to read the intro so far. I'll probably read some either tonight or tomorrow, and because I want to review it, and then I want to invite him on to talk about it as it's being released, so that people know about it. And I think the guy is one of the most fascinating men in America right now. And he's one of the last journalists left alive in the true sense of the word.
Him and Tom Fitton. Tom Fitton is doing what used to be done by journalists, but he's doing it with gigantic pecs.
And Andy No is out there doing the ground level journalism.
Andy No is another client of ours who we're working on various stuff for him. We knocked out that copyright case that had been filed against him by having a stern talk with the plaintiff's attorneys there that went along the lines of,
Wait, briefly, what copyright case was filed against Andy No? I'm not familiar at all.
a lawyer who I happen to know. So funny thing.
It was Joe Neerman. That's who it was.
Thought it would be a good idea to sue Andy No for copyright infringement because he was using Antifa videos on Twitter through the video retweet feature.
So he was retweeting inside the Twitter mechanism,
right?
Which, if you read the Twitter license agreement, is obvious that you can do that.
So Harmeet and I got on the phone with this guy, and after a brief chit chat about how nice it was last time we had a corned beef together, Harmeet, always the bad cop. Did you even read the terms of service? And I don't know if it was 24 hours or 36 hours later the case was unilaterally dismissed.
Okay, so I want to table this discussion with you, and I'll preface it because I would love to talk to you about this on this sort of topic. Does Twitter's terms of service give a license to use Twitter posted material offline, off of Twitter? Because the way it's written, it kind of looks like it does. I don't think that's what they intend. And I don't know if a court would accept it, but so we can, I think we can do a show on that.
The court would not accept it just because judges really don't understand copyright and trademark law.
Right.
But if they did, I mean, when you say use it, inevitably you'd be talking about using it in a fair use context and purposes of news commentary or analysis. It's hard for me to imagine, but that's another one in the Ron and Nick series. You have a lot of series is going now.
Well, I just think that's a fascinating topic. It gets brought up all the time. There was a little while where a lot of YouTubers I know were getting DMCA struck by bringing up people's tweets. And I'm like, wait a minute now. You're posting this publicly. Twitter's license agreement says for us to use or anyone else in the world to use anywhere. It's in the terms, and they're extremely broad.
But it's also, if they're bringing them up, they're doing it as news and commentary.
Right.
Saying, look what this tweet says. I mean, that's just classic fair use.